previous case, Lordship. Again, the complaint has been quashed. But on the apart from the merit, before I add this on the merit, but there are, I will say, Lordship, we can still
Not heard.
Yeah, but not heard. And
Any delay?
no, there is no delay, Lordship.
Should notice to the respondents.
I'm grateful, Lordship.
Is a respondent there?
The state, but it's a private complaint. It's a second respondent. The state is also there. Third.
It is reserved to the permission is granted to the petitioner here it to serve the standing counsel for the respondent.
Your Lordship may kindly see, my Lord's page 56. My Lords, the date has been tinkered, tampered, completely forged.
The complaint is quashed.
Complaint has not been quashed, my Lords. There was a stay, but then High Court refuses to quash.
That is dismissed.
The 482 is pending. Now, my Lords, the position here is your Lordship.
Only we wanted to know how the complainant is connected with the check.
Lords, the complainant and the respondent, my Lords, were both partners earlier under a partnership deed. Thereafter, there was a reconstitution of a partnership deed. Thereafter, this check was given in 2020.
Notice to the respondents. Any delay?
Lords, there is no delay. I'm seeking stay of proceedings.
What has happened now?
My Lords, they have summoned us, my Lords. Cognizance has been taken.
What is the next date?
9th, my Lords. 9th.
Today is 9.
Today, in fact, my Lords.
Right. Stay of further proceedings.
Obliged.
In so and so, give that thing.
Very well.
Till the next date of hearing.
Right.
Give a date in end of November.
Very well. I'll
End of November. Yes. Till the next date of hearing, give a date in November.
Yes.
Arises out of the refund. Now, what has happened in this matter? 103 bill of entries were filed.
1 minute.
Yes.
Now the High Court order was given effect to.
Yes.
So therefore, we did not interfere.
Yes.
Now that after that, all the authorities have said refund. 1 minute. Testat says refund. High Court has said refund. And there is 175 days delay. Even if you withdraw, we want to impose cost in this case.
But the issue is...
Earlier it was already done. 175 days delay. Even if you withdraw, we want to impose cost.
No, my lords, may I just explain this? Now, so far as
Not the way to treat SSEs.
Not at all, Your Lordship. Just
what has happened?
Just hear me for 5 minutes, Your Lordship, in this matter.
Let him say.
Yes. My lords, what has happened in this matter? In the initial round of litigation, when we have approached my lords, because there was no stay operating against the High Court judgment.
Remand order.
It was a remand order determining certain issues, Your Lordship. So therefore, on the basis of that, the additional commissioner appeals and CSTAT has determined the issue in favor of the SSE, against which we filed an appeal before the High Court. Now, what has happened before the High Court? High Court has misconstrued the decision of my lords, because my lords have clearly referred to in that order that all the contentions of the department are open.
What is your contention?
Yes, sir. My lord, the contention is, so far as the refund claim is concerned, that is barred by limitation as well as adjustments by relying upon 9 judges bench decision.
Oh, don't tell us 9 judges bench.
My lords, I will make my submissions good on this.
Is he entitled to refund?
Not at all, Your Lordships. Because it is a case of self-assessment. A 3 judges bench decision of this honorable court has clearly held that self-assessment is also an appealable order. Now, instead of filing an appeal, I want to show those judgments, Your Lord. Instead of filing an appeal, he has straight away filed a refund application that is clearly rejected by this honorable court.
Necessary.
My lord, it is required. That is a mandatory requirement. May I just show those decisions?
See, unless you make a representation first for refund.
Not at all.
How will the department know? How will the department consider?
My lord, yes. For that purpose, he has to challenge the assessment order on the bill. So, yes, this is what I just want to.
What do you have to say?
My lord, this is not the basis. If your lordship says the first High Court order of Justice Bhatt, which your lordships didn't interfere with, Justice Bhatt says there is a Supreme Court judgment in favor of the SSEs, admitted case of the department that they failed to implement it on the system, because of which, my lord, the higher duty has been paid. Justice Bhatt relies on Article 144 of the Constitution that it is a duty of the department to implement Supreme Court judgments immediately. Because of your fault, if somebody has paid higher duty, you cannot turn around and say that now delay and all of this.
No, my lord, that is not the case here. That is not the case here.
That is the case here.
My lord,
it's very unfair.
My lord,
very unfair.
The judgment. My lord, may just give me 5 minutes.
1 second.
If this is the attitude of the
not at all, Your Lordship.
We are telling you, your collection of taxes will become difficult.
My lord, there is no question. It is a self-assessment, Your Lordship. It is not the department has initiated any recovery proceedings. It is a case. My lord, I just need to show.
There is a delay of 175 days in filing this special leave petition. We also find that the department ought not to have challenged the order of the High Court in the instant case.
Well, even if it is contrary to constitutional bench judgment as well, larger bench.
We hence dismiss this special leave petition. However, we refrain from imposing any costs in the matter.
Deeply obliged.
It is, my lord, now I can show those dissent at least.
No, you can't.
On merits, it is squarely in favor of department, your lordships.
Please don't hound SSEs.
Not at all. This is not that case, your lordships.
Yes. That means there are other cases where you hound.
No, my lords. What I am saying is we are right now on this case. We are right now on this case, your lordships.
There is also delay also, both on delay as well as on merits.
Which shows that I was in position. I have been in position. And the written statement of defendant number 1, who is my vendor. So please see page 24. Now court says 53A. Because 53A would not apply for the suit for injunction.
So what was the suit for?
Suit for simpliciter perpetual injunction. I was put in position by defendant number 1. Defendant number 1 and 2, 3 are brothers inter se. They later compromised the suit. There was a dispute going on between both of them. Now, I had filed a suit seeking injunction on the basis of agreement to sell, which was executed by defendant number 1. That I wish to show it to Lordship at page 23.
But that consent decree has not been proved by the plaintiff.
That has not happened.
And that goes to the root of it.
But there are
All
two
the
things.
3 courts, that's why I have dismissed.
Defendant number 1 admits in his written statement that I am put in position. Therefore, please see this, my lord, page 37. This one document, page 23 is the agreement to sell, which meant.
If you had proved that consent decree, then you would have been on a better footing.
I could not because it is between them.
You could have asked for the summary of that document. You did not.
I don't think so. That is actually necessary. What the court ought to have seen, whether I am in possession or not. Now there are two.
Whether you are in possession or not, if you are not in possession, they will file a suit for possession. No, you don't express anything.
Now they will take it away, my lord. Since there is no injunction in my favor. Therefore, my lord, there are 2 documents and I leave it at that. Lord, page 23.
See, if you had proved that the compromise decree, you would have been a better. Sorry.
Lord, I am not even harping upon that. Because there are 2 documents which I wish to show. One is page 23 at 24. This is a registered agreement to sell in my favor by defendant number 1.
That's all right.
Now the second is page 37 if your lordship see. This is, yes, 37. One of the brothers, my vendor, he files a written statement accepting my possession.
Correct. What to do now?
I am in possession, therefore my possession needs to be protected. They can evict me by following procedure. They can file a suit for the possession. Page 34 if you watch it.
Your suit for?
My suit was for perpetual injunction.
Correct. Now
that's saying that I am in possession, I have been put in possession.
The suit is dismissed. It means what? You are not in lawful possession. If you are not in lawful possession, then the possession has to be given. It doesn't belong to you. The possession doesn't belong to you.
2 documents are not considered by the courts.
All
this
the
is
courts.
the
And
addition
that,
by defendant number 1.
The compromise had been proved, that consent decree or whatever compromise had been proved, you would have been in a better position.
If your lordship sees page 38.
We don't want to say that possession has to be taken in accordance with law. Then what will happen? They will have to file a suit.
They will have to. They will have to.
Another 30 years.
Because there, if they file a suit, my lord, I get. Then may I in the alternative, may I say, my lord, I'll take an alternative remedy, my lord. Okay. I have a remedy to seek specific performance of the agreement.
No, not. You have already filed one suit.
No, that is for injunction.
Granting you any liberty.
No, I am saying, I'll withdraw it and I'll file an appropriate.
We are not giving you any liberty. If you want, you can withdraw.
No, your lordship may just record my statement.
We are not recording that also.
Very well.
Because one order cannot give rise to another litigation. That too of this court.
Then
constructive like res judicata also applies.
I'll simply sit a withdraw it.
Turn it. Substitution application allowed. Turn it senior counsel for the petitioner sought permission to withdraw the SLP. This submission is placed on record. SLP is dismissed as withdrawn.
Very well. I'm so